Hello, welcome everyone. I'm letting folks in from the waiting room right now, so just give us a moment and we'll be getting started here in just a second. Okay, so welcome to our webinar. This is the Divorce Foundation series, a 101 guide to Washington State family laws and what to expect. And I'll be joined here in just a moment by Michelle Dellino from Dellino Family Law Group. And I just take a quick moment to introduce myself, introduce Michelle, tell you guys a little bit about what to expect for this webinar, and then we'll just get into it. My name is Melissa Rosenberg, and I'm actually a therapist here in Seattle, Washington, specializing in working with clients who are navigating different stages of the divorce and separation process. So I work with clients on the early end of things who are trying to determine if divorce or separation is where they're headed. I do work with clients who are more in the middle of complex and emotionally challenging family law situations. And I work with people on the other end too. I also do work with couples who are trying to undergo marriage repair to try and avoid separation or divorce if that's their better path. So a lot of different things, but today I'm here as a facilitator for this webinar. And what we're going to do, I'm going to turn it over to Michelle, and she's going to deliver a lot of information just about kind of the 101 guide to Washington State family law and what to expect. As stated here, this is a foundation series that we do monthly. But the other opportunity is to ask questions, which is really a valuable part of attending. And what we're doing here is offering the opportunity for you to ask more general questions. This is not case specific time for you to get, specific information into the details of your own situation. But if there are general questions that you have, it's an opportunity to pose them, see if we can get them answered for you. And likely they're going to be useful to other people who are here watching today too. So we have been out about an hour. Again, Michelle's going to go ahead and present some information. And if you have questions, the way you can ask them is by posing them in the chat. Those questions will only come to me, and then I will pose them to Michelle, and hopefully we'll answer as many of them as we can. Trying to think what else. I think that's it for now. With that, I'm gonna go ahead and turn it over to Michelle.
Hi, thanks for being here. I'm Michelle Dellino. I am the owner and founding attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we actually help clients all over Washington State navigate divorce and separation and other family law issues. So the first thing I will tell you is I'm an attorney, but I'm not your attorney, unless I actually really am, and you have an attorney-client relationship with us. But the point of that is to say that anything I tell you today is legal information. It's not legal advice. To get legal advice, you need to have an attorney-client relationship and have a confidential setting with your attorney. So that's not what we're here to do today. But we are here to give you a lot of information that will hopefully be helpful. We're going to go over the basics of divorce in Washington. We're going to go over what the main issues are. We're going to talk about that. Like Melissa said, I'm totally happy to answer some of your questions. The more detailed and fact-specific they are, the more difficult they are for me to answer. And the more that indicates you probably need to talk to someone, even if that's not me. So we're going to start with some of those things from the top. And again, I would indicate to you that the more that you can send those questions to Melissa confidentially is probably the better, unless you really want them out there for everyone to see. And if you don't care about that, you can do it that way too. But anyway, that said, all right, let's start. First of all,
Hold on real quick, Michelle. Sorry to interrupt. I didn't mention the Q&A. So there is the Q&A tab on the bottom. The chat questions do just come to me. If you ask a question in the Q&A, that's also an option. It just means it'll pop up for everyone to see the question. You can mark yourself as an anonymous attendee, so no one will see your name, or you can keep your name, up to you. But those are the two different ways you can ask questions. Sorry about that. Go ahead.
No, no worries. Thanks for clarifying. Okay, so first of all, about the series, if you've watched the Divorce 101 before the Foundation series, it's pretty similar every time. I talk about the main issues. What makes it different is your questions. Although today I've decided to structure it a little bit differently, I'm actually going to talk about what does a divorce attorney actually do before we get into the issues, because a lot of people are here that want to know, like, do I need a divorce attorney? And I'm also, just so you know, I'm not here to tell you that you need a divorce attorney because I am one. Like, I'm not here to do that. I'm here to tell you this, and this, I mean, actually genuinely from my heart, which is going through a divorce is the undoing of the most complicated legal contract you're ever going to be in with another person. A marriage is a legal contract. Yes, it's a lot of other things too that are supposedly good at the time, but it is a legal contract. And so what you're doing when you get divorced is you are undoing that. And you might think, I can't afford to get an attorney. Well, that might be true, but in a lot of cases, you can't afford not to, especially when you're looking at what the difference could be for you. So when I tell you, or you ask fact-specific questions at some point in this webinar, which someone will, and I will say, hey, I think you need to talk to an attorney, it's because what you're doing is you are undoing a legal contract. And just in the same way, like I know a lot about a lot of things, but in the same way that I do not do my own taxes, I don't try to perform surgery on myself, I go to somebody that knows, even though I know a lot about a lot of things, and so do you. So you should go to somebody that knows and that can protect your interest. And so that's why I'm going to start with, what does a divorce attorney do? Do I need one? You at least need to consult with one, would be what I would tell you. Even if you have almost nothing, you still need to make sure that what you're doing is in line with what the law would give you. Because a lot of times people think, oh, I don't want to ask for too much. I don't want to, give up too much. Well, you need to know what your rights are legally and where you stand. So do you need one? I say yes, or at least probably for a consultation. So a divorce attorney plays a crucial role in handling divorces that involve assets, spousal support, child custody issues. There are four main issues in divorce, and we're going to get into those. And if you have kids, there's four. If you don't have kids, two of them don't apply to you. But the first one in every case is the division of debts and assets. And that includes figuring out what's community property, what's separate property. Once you figure that out, you've got to figure out how to divide it. You have to do that in literally every case. And what is it? We'll get to that. It can be a lot of different things. The second question is spousal maintenance an issue in my case? And if so, how does that get decided? So spousal maintenance or spousal support is the Washington term for what other states call alimony. What that is a post-divorce payment from one payment to the other, or a temporary payment from one payment to the other. So is that going to be an issue in the case? It's an issue in a lot of cases, not every case, but it's an issue in a lot of cases. You at least have to decide one way or the other whether it's an issue. The next one are parenting plans. You cannot finalize a case with children without a final parenting plan. And you need to know what that looks like, what's included, what to do if you have concerns about what to do if you have concerns about somebody's substance abuse or other domestic violence or any of those things. How does that play into a parenting plan? The last thing on top of that is child support. You have to have a child support order. Even if you don't want child support, you have to have an order, and it has to address things like who pays insurance, who claims the children, what's the payment from one parent to the other, how are expenses paid. So you have to have those things. Those are four things in any divorce with children. There are also what I would call ancillary issues that still need to be dealt with. Who's going to pay attorney fees is one. Is there going to be a restraining order or a protection order is another. What other kinds of restraints might exist? Is there going to be a temporary financial restraint in my case? So all of those kinds of things are issues that are kind of under the umbrella of the four main issues. So what does a divorce attorney do? They help you navigate what those issues are. Our responsibilities are legal representation, negotiation, whether that's at a mediation just through one party to another, or going to court. So those are basically what needs to happen. And the responsibility really is to ensure that a client's rights are protected. So that's what we do. And I think it's important to get that out there. Legal representation doesn't necessarily mean you're here to fight. There's a big, I think, misconception that attorney means you're going to go to court and you're going to fight. That's actually not true. Attorneys are also advisors. And I would say that the vast majority of cases do not go to court and there is not fighting. Or if they do go to court, it might be for something like a temporary orders hearing. Less than 10% of divorce cases are resolved in a trial overall, less than that. So a lot of the time, what you end up doing is you end up trying to negotiate things. You end up resolving your case in a mediation, even if you might have had a court hearing at one point. So the odds of your case going to a trial are pretty slim, although it does happen at times. So now that that's out of the way, it's important to talk about the four main issues. And before we really do that, I like to also talk about what are the requirements to file for divorce in Washington. We do have a residency requirement, and that's really important. At least one spouse must reside in Washington state at the time of filing. So In Washington, unlike some other states, there's no minimum residency period, meaning a spouse can file immediately after they move here if they want. However, if one state doesn't live in Washington, you're going to need to talk to an attorney to determine whether there's jurisdiction over another party or property. So a really common scenario here is one party moves away. Like let's say you lived in Washington together, one party moves to California and one party remains. So there's going to be jurisdiction over that other party. You don't need to worry about it. But another scenario is the parties lived in another state and you moved to Washington. The other party's never been here. You weren't married here. They have no ties here. There may not be jurisdiction over them. So anyway, but you need to know if one party lives here, if you live here, you can file for divorce here. It just becomes more complicated if the other party doesn't live here, if there's jurisdiction over them. Same thing with children. So children, there is something called the UCCJEA, which is the Uniform Child Custody Jurisdiction Enforcement Act. What does that mean? It means that wherever your children have lived for the last 6 months is what's known as the home state of the child. And the court then has jurisdiction to enter orders that will have an impact on them. What is jurisdiction? Jurisdiction means it is the ability of the court to enter orders that tell someone to do something. Like if a Washington court has no jurisdiction over somebody that's never been here and has no ties to our state. A Washington court has no jurisdiction over your children if they've never been here. So those are things to know. But if everybody lives here, everybody's been here, then jurisdiction's less of a question. But sometimes it does come up, so I like to talk about it right away. Grounds for divorce in Washington, let's cover that. Washington, like most other states, is a no-fault state. So that means you don't have to prove fault to get divorced. If somebody wants to get divorced, they can get divorced. You can't stop that from happening. You might not want it to happen, but the only ground for divorce is the claim that a marriage is irretrievably broken. Nobody has to prove that. All they have to do is check that box and put that in their petition. You don't need to prove any kind of wrongdoing. A lot of the time, people need to know that no-fault divorce is a real thing because people will say, I'm the victim of domestic violence, or this person was abusive, or this person cheated on me. All of those things, while they're not great or okay, you're not going to have more money allocated to you because there's fault the way that you might in a fault state. Like you might get more money if somebody had bad behavior in a fault state. I think there's only 2 fault states left. But anyway, long story short, bad behavior or abuse or things like that, they might play in other ways, but they're not a basis for property division. So that's also important for you to know. And the good news there is if you don't have to prove anything, you can get divorced if you want to get divorced, right? Waiting period. Let's talk about that. There's a 90-day waiting period after filing for divorce before a divorce can be finalized. But I'm going to be really upfront with you. 90 days is a fast divorce. Divorce is a marathon. It is not a sprint. I always mention this because I really like it. I have a friend and his name is Rafe Palmer, and he owns a family law firm in Chicago. And his book that he wrote a few years ago, which is a really great book, it's called I Just Want This Done. And I love that because that is how every client feels. I just want this done. I want to rip that Band-Aid off and I want it done. Like, I don't want to talk about it anymore. I want to know what's going to happen and I want to move the heck on with my life. I get that. But I'm not doing you any favors as you approach the divorce process if I tell you, oh, this is going to be over easy within 90 days. I mean, is it sometimes? Sure. Is it most of the time? No. And that doesn't mean that it's going to be a fight, but it means it can take time to exchange financials, figure out if you need to get values on things, figure out who's going to stay in what home, figure out where your kids are going to live and if that's best for them, get a custody evaluation, kind of go through some of the things that you need to go through. Your marriage, like I said, is a binding legal contract and there's a lot of intricacies and it's a major life change. So it's going to take you time to undo that, whether you really want to or not. It's not going to be probably over 90 days. I like to use King County as an example. We're located in King County and a lot of divorce happens here, just like in other counties, but especially here. It's the largest county in the state. In King County and some other counties, there'll be what's called a case schedule that's generated at the beginning of your case. It will give you certain benchmarks through the case when you have to do things. You have to take a parenting seminar. You have a date that you have to engage in dispute resolution by. Things you got to do, right? And your attorney, a lot of those deadlines are for your attorney when discovery has to be done. So, but the telling part of that is It sets a trial date in your case that you're probably never going to go to, but that's a year out. So it gives a year for the process to unfold. So anytime you have children or assets in controversy, it just even in the most cooperative divorces, anywhere between 6 months and a year is pretty reasonable, and 6 months is still pretty good. A contentious case is probably going to take 1 to 2 years before it ever goes to trial or anything happens. So these are things for you to keep in mind. I like people to get off on the right foot, and that is having realistic expectations. Okay, now, before I launch into the big top four topics, I do like to say one other thing, and then I'll take some questions. Really, really, really important. So important that I think at one point we put it on our website. I don't remember, but I think we did. When you're getting started, you need a support system. And there is a difference between a support system of posting all about your case on social media, so everybody knows what's going on. Everyone's like, oh, Jane, oh, let me tell you, she's going through a divorce. I saw it on Facebook and Instagram and whatever. Like, Jane doing that, that might feel good to her, but that's not the kind of support system you want from your entire everyone, because anything that Jane posts is probably going to be used against her and taken out of context. So don't post about your divorce on social media. You can, even if you think your universe is closed, you never know who's a friend of a friend. You never know what's going to happen. I highly recommend you do not do that. What you do want to do is have support. Know who those core people are. Let your parents know if you're close to them. Let your really best friends know, and let people know what you're going through. Identify your key people and keep your circle small. Get professional help. A lot of people will ask me as an attorney, if I have a therapist, does that look bad? Does it look like something wrong with me? No, it looks good. It looks like you're taking care of your mental health and prioritizing it, especially if you have children. So gather your support network. And Melissa can talk about that too briefly before we get started. And I cannot stress to you how much less your attorney's fees will be if you can work on how to process your divorce, how to do certain things with a therapist and not with an attorney, because their rate is better than ours. Sometimes they take insurance, and I can't help you feel better about your divorce, even though I'd like to. I don't have the skills to do that, but someone like Melissa does.
Yeah, I mean, I think it's really important to just underscore that it is so important to have adequate emotional support while you're navigating this. There's so much to be, processed and worked through with your legal team. And in order to be grounded enough to do that, in order to be able to show up to those meetings and be able to, be as, calm, cool, and collected as you possibly can be, given everything that's going on, and be able to really integrate and process the information that's being given to you and be able to do what you need to do to gather the right information. You want to make sure that you're being emotionally supported properly. There's just so much that comes up, and in terms of grief and compounded grief and sometimes traumatic situations and challenging dynamics and trying to deal with this person who might still be a co-parent or who you're trying to separate from. There's a lot going on here, and so have adequate support in your personal social life as well as some additional professional support. I work with a lot of clients who are going through the divorce and separation process, and I really, really, can't stress enough how important it is to make sure that you have, your village comprised going through it.
Yeah, it really is. It's going to help you in the long run. All right, I'm going to start talking about property division, but before I do, Melissa, there's probably a few questions at this point that
Yeah,
you
we
can
do
answer.
have a few questions. Okay, here's one. With regard to spousal support, this person saying they're concerned because they've been out of the workforce for 8 years. How does that influence the amount and duration of spousal support? We talk a little bit about that. They're saying they're 56 if it matters, but just what is it like if you've been out of the workforce for a while and you're looking at spousal support?
Well, it's scary. I know that. If you're out of the workforce, it's scary. And there's a number of reasons. Sometimes someone stays home. Most of the time in a marriage, if someone has been out of the workforce, sometimes they've stayed home and took care of the kids. Maybe they had a health issue and didn't work for a while. Maybe the parties just agreed they were going to take care of things at home while the other person earned most of the income. There can be a lot of reasons, but realizing that you need to go back to work can be very scary. And needing some support during that duration is completely normal, and it's what the law typically allows for. So we'll talk about spousal maintenance. Generally, and I'll just talk about this for a second, and then I'll take another question, and I'll come back to spousal maintenance in a more comprehensive way in a few minutes. But spousal maintenance in general, it is a situation where there's a number of factors that are fact specific, looking at the income of the parties, the expenses, the length of the marriage, the financial situation of the parties, the income potential. There's a lot of different factors. But if you haven't been working in 8 years, I will tell you this, are you going to have a job? Yes, unless you're disabled, you're going to need to get back into the workforce in some capacity. Otherwise, the court will see you as voluntarily un or underemployed. However, it's a tough job market in general, and it's really tough if you've been out of the workforce to get something probably that's going to be able to sustain you on your own. So, spousal maintenance, if the other party has always been the breadwinner and is the breadwinner right now, is something that's probably on the table for you. As far as your age goes, so you have working years left. So that's different than if you were retirement age and the parties are retired. Then we're talking about, we're talking about pre-tax money then being used in retirement. We're talking about a number of other things, but it doesn't sound like that's the case here. But are you going to get maintenance? I can't tell you for sure because I don't know the situation that you're facing, but maintenance is, like I said earlier, a post-divorce payment from one party to the other for support or a temporary payment while the case is going on. And if you're not working and you've been out of the workforce for 8 years, you probably at least have a good claim for maintenance. And then the actualization of that is going to depend on your situation. And we'll talk about that in a little more in a minute. Anything else?
Yep. A few other questions. Is a dog considered an asset? How would the decision on who takes care of the dog play into spousal maintenance? Like if one person's the breadwinner, pays spousal maintenance, and also takes care of the dog, would the cost of taking care of the animal be determined at all, be
Tell you
considered at all?
what, like I laugh about it just because like I have two dogs. They're really expensive dogs. One is
The
uh
most expensive dog.
yeah, and the most expensive dogs. I have a history of the most expensive dogs. So, but no, dogs are property. There's no custody schedule for dogs or any cats or whatever pets you have. I had somebody once fighting about some snakes, but pets are property in Washington. I mean, to me, they're family members and probably to you too, but it's not determined that way. And there's not a value assigned to them. And there's not going to be any increase in spousal maintenance because you have to take care of them. Like I have a dog right now that just went through a really extensive and expensive spinal surgery about a little over a month ago, and he's already paralyzed and in a wheelchair. So, um, as you can imagine, like if I got divorced and was like, "Hey, you're gonna take care of the dog," yeah, unfortunately, even in that kind of a situation, you wouldn't be looking at, oh, if somebody has to pay for his vet care and his food and his follow-ups and his wheels, there would not be additional money allocated for that. But anyway, that's something for you to know. Dogs are property, even though we don't feel like they are, the court views them as that. So what happens is there's a determination of who's getting the dog, and that has to be decided. And sometimes there's really contentious fights over that. So then we talk about what's practical and what that might look like and who's taking care of the dog customarily and things like that. Great question.
Thanks. That's really helpful. It is a good question.
Mhm.
Okay, another person's asking if we're not at the point of divorcing yet, but it's being considered, what can we do to prepare for a smooth divorce now, if or when it comes to that? We don't have a prenup. We want it to be as amicable as possible.
I love that you were like smooth divorce. That'd be great. I love a smooth divorce, honestly, but there's not very many because people's um, interests are not usually similarly situated. So you can have a divorce that is cooperative, and that sounds like that's what you want, and that's usually what I think is best. It's best to try to be fair, know what your situation is, and ask for something that's fair and negotiate from a fair perspective, but also firm. This is important to me. I'm not going to budge on this one or two things, and knowing where your breaking points are, and friendly, be amicable. Just because your marriage is ending doesn't mean you need to, well, someone told me this, don't roll in the mud with pigs. Don't get in the mud and roll around for no reason. You don't need to. So, yes, what can you do? Great question. If you both know that you want your marriage to dissolve, one thing you can do, a couple of things. You don't have a prenup. That would have been the number one thing. You could still do a postnuptial agreement or a separation contract if you wanted to. And so what that would look like, in my opinion, would be, working with attorneys, not getting divorced yet, and maybe you don't get divorced. Sometimes this is really interesting. I've had clients that are like, we want to do a postnup or a separation contract because money's been an issue and we want to know what that's going to look like. And then, they have to work through some of that and then they realize those things are resolved and they don't get divorced. But if you do get divorced, you're going to have to deal with all four of the issues that I talked about. And sometimes the property division and the spousal maintenance is the unknown of that creates acrimony, which means negativity. I say acrimony, people are always like, what does that mean? And I always catch myself saying it and try to strike it from my vocabulary. It means negativity and fighting. So fighting happens when people are not sure what to expect. So you can alleviate some of that by having those conversations or trying to come up with an agreement before anybody files through counsel. However, if you're not there yet, and you don't even want to have those kind of conversations, one thing you can do is you can work on a budget. You can each work on what would my budget look like once we are separated. And then you'll have an idea, what's it going to take to sustain me? What's it going to take to sustain you? And everybody's a lot more on the same page because that's something that is part of the divorce process is figuring out what is your financial budget going to be? Do you make enough? And where does, the money go from A to B to make that happen? So figuring out your budget is a really, really good first thing. Getting on the same page about major assets. You guys, if you have a home, you don't have to know the details now, but is the general idea to try to have somebody keep it? Maybe somebody stays in it with the kids, or is the idea that, hey, we're ready to sell it, and then thinking, we don't want to sell it in December, maybe we want to sell it next spring. Getting on the same page about what's going to happen with major assets like a home can help pave the road for a cooperative, or as you called it, smooth divorce. So getting on the same page about assets, contemplating a separation contract or a post-nup that you may or may not need, getting a budget together, those are all really good first steps that you can take.
Awesome. Thank you. There's a handful more questions. Do you want me to keep going?
I'll take two more, and then I will talk about at least asset and debt division and community property, and then I'll in between the sections.
We'll come back. Yeah. Okay, this person's saying a mediator that they talked with and liked seemed confident that their divorce could be finalized within 120 days. Hearing what you've said, that seems overly confident. Does that seem overly confident to you? And also, could you recommend any mediators for a low conflict case?
Well, that's a very loaded question. I can't tell you. Could your case be done in 120 days? Yeah, if you've got nothing to fight about, it should be done in 90. But if you guys are all on the total same page, if you're both coming in and you're like, we just want to split everything equally, cool. Maybe you can. But this will get into this in the first topic of discussion, but a lot of the time what ends up happening, I will stress this to you, there's different types of mediation. I'll tell you this too. I'll just answer this question this way. 120 days, maybe. If you really agree on everything, yeah. But you might not know what you don't know, which is you might think, oh, splitting everything equally is a great idea. You might not know that that's literally what would never happen and that that's a home run for the other party. You might be giving up tens or hundreds of thousands of dollars and doing that and not know it. So all these kinds of things, like, could you? Sure. Is that the best thing for you? I don't know. Right. Second thing is the different types of mediation. Can I recommend great mediators? Yes. I settle most of my cases in mediation. So does any other competent family law attorney. But there's different types of mediation and mediators. I can also tell you the kind of mediations I don't recommend and the kind of mediations that end up costing people time and money and the kind of mediations that end up leaving you so you leave there with no binding resolution. And so here's the thing. I never recommend that you work with a non-attorney mediator. If you're going to a financial person, they're not a lawyer and they don't know what the law says and they can help you tell you how to divide your assets, but that's not necessarily helpful to you. And I know some good mediators that do that. I have a couple that refer to me and they're like, I've taken this as far as I can. You need to go talk to a lawyer now. But if you want to waste your time with that up front, that's up to you. The kinds of mediation are this. First is the kitchen table divorce mediation, where party A and party B literally sit at their kitchen table and bang it out and nobody else is involved. That's one. Probably not going to work for you. If it does, great, but I still recommend you run your settlement by an attorney to know if it's fair. Number two, the facilitative mediation. This is a mediation where neither party has attorneys and you go to a mediator. Sometimes it's an attorney mediator, sometimes it's not. Either way, they are facilitating a resolution. One mediator, even if they're an attorney, cannot give you both advice. The rules of professional conduct for attorneys in Washington state prohibit that attorney from acting in a situation of advising either of you because you guys are not on the same page. They can't say, hey, this is a really bad deal for you. This is a good deal for you. You should or shouldn't do that. They can facilitate what might happen and what it might look like, but they can't give you legal advice. They literally can't do that. And so they're facilitating the resolution and you guys working it out. but you're not getting advice. And you don't really know. You don't leave there really knowing, was this a good deal for me or not? And they aren't going to bind you to a settlement. They're going to tell you to take it to an attorney that's representing you and draft it and have you sign it. They're going to have you sign what's called a memorandum of understanding that says, we understand this is what we agreed to. Now go put it in final orders. So a lot of people come to me with a memorandum of understanding, also known as an MOU, and say, here. And I'm kind of looking at this and I'm like, this is your worst case scenario. Oh, your community's worth this much. You can agree to this, but why would you? And then you got to start over. So you don't
Mhm.
really know. And does that kind of mediation work for some people? Sure. Does it work for others? Absolutely not. Then there's what's called an evaluative mediation. This is the kind of mediation that I've been doing for 16 years, and it's the kind of mediation that resolves cases in a very equitable way. We haven't talked about equity yet. I'm going to talk about that after this question. So what does that mean? Facilitative mediation would mean you would sit in one room with your attorney, and it used to be we did these always in person. Like I'd be in one literal physical room and the other person's on the other side of the building or the floor in another room with their attorney. So you aren't seeing them. And then the neutral attorney mediator shuttles back and forth. It's basically an evaluative mediation in a shuttle format. The mediator shuttles between the two rooms, bringing offers back and forth and evaluating the position of the parties. Like your mediator will come in because they've tried family law cases and they know the law, and your attorney will have told you something and they're going to be like, yeah, she's right. Or they're going to be like, hey, these are the weaknesses in your case. You need to think about this. And they're going to do the same thing in the other room. Or they're going to be like, you're being completely unrealistic about parenting. These are why. Or they're going to be like, they're going to evaluate your case and they're going to help you work to a resolution. In the most difficult cases, with a good evaluative mediator, attorney mediator, are going to settle 90% of the time. The ones that don't, there's either something that's too big to fight about, too much in controversy, or there are intangibles that people aren't getting on the same page about realistically. So there's different types of mediators. I can tell you different ones for those types, facilitative or evaluative, but that really is going to be dependent on your situation. But I think it's really important that you understand the differences. When you go to an evaluative mediation, you're going to leave there that day if you settle with what's called a CR2A agreement. That is a settlement agreement that refers to Civil Rule 2A, which is an agreement that says even if the orders aren't entered in court, if everybody signs this, it's binding and no one can change their mind. And then we reduce it to orders. It means your case is done. And that is a huge, huge, huge thing. You can resolve your case in one day. There's usually not multiple sessions. It's just done. You have to do a lot of prep work to get there, and it's an emotional day. But you're in a room where you can get private, confidential advice as you go along. You can ask the questions. You can say the other party's an asshole. You can do whatever you want, and it's private. And it is going to get you most of the time where you want to be. It's a very big and important day, and it's going to help you avoid a trial. If you go to a facilitative mediation, you might all sit around the table and talk together, and that might be fine, but you're probably not going to leave there with a binding resolution. The last thing I should mention is collaborative law. Collaborative law, it involves a different type of process. Everybody gets a collaborative attorney, there's a collaborative team, and you meet together in a series of meetings all together in what's called a collaborative container. It's not a process that I recommend because if it doesn't work, you have to start over with other attorneys. But I'm not here to talk about collaborative law. So anyway, those are different types. That's a really long answer to your question, but I try to give more information rather than less, and hopefully that's helpful to you. I'm going to talk about asset and debt division, and then I'll come back and take more questions. So like
Sounds good.
Washington, every divorce case has to identify who's taking the assets and who's taking the debts, who's getting what, right? And usually when you start a case, all you say in a petition is, if you don't have a prenup that you're following, all you say in a petition is the decision will be made about property later, something that's just and equitable. Why does it say just and equitable or fair and equitable? Why? Because those are the magic words in Washington. Because Washington is a community property state, but we are not a 50-50 state. What that means is so important. A lot of people think it means I get half and you get half. Sure, in some states, but not here. It doesn't mean you might not end up with a 50-50 division. Sometimes you will in a shorter or longer marriage, but a lot of the time you won't, and it's not automatic, and it's maybe not what's best for you. We are a just and equitable state. So that means that a Washington settlement wants to know more about your marriage. If you were in California, and I use that because it's the biggest community property state that's 50-50, nobody cares how long you were married. And nobody cares how much money you make or if you've been a stay-at-home parent when you get divorced, as far as property division goes. You're each getting half, no matter what. That's not the way it works here. How does it work? First thing you do is you figure out what's in the community. Well, the community starts when you got together, either when you got married or maybe when you began cohabitating before, which is another issue, and it ends when you separated. Not necessarily when your divorce is final, but when you separated. Maybe when someone filed for divorce, maybe when someone moved out. That's a date that you need to discuss with your attorney. But there is a community period. All the assets go in there. 401k, retirement, the house, the cars, the dog, all of that goes in there. And then you figure out, how does it get divided? Okay. And are there any things in that community pie that we take out? Things that we take out are money that is earned from separate property. If I had a rental house, I owned it before marriage, and I'm getting income during the marriage, sure, that's income that's earned during the marriage, which income is usually community property, but it's from a separate property source. So that income, that's mine, that's coming out. Did I get a gift or did I get inheritance during that period? Gifts and inheritance just to me are separate. Okay. And those come out. So those are some really good examples of separate property. But then you look at what's left and you got to go, how do I divide this? Right? This is the magic question. So first thing, is your marriage short term? Is it midterm? Is it long term? It's not technically long term unless it's 25 years or more, but if it's getting up there, that's helpful too. Is it short term, 5 or 6 years or less? Or is it in the big midterm medium, which most marriages when people get divorced are? Okay, so then we know that, right? Different purposes for different lengths of marriage. In a short-term marriage, the purpose is put people back where they started. Nobody's relied on the community that long. Usually just split whatever's community equally and go on your merry way. Midterm, it's a lot more complex and a lot more to fight about. We see property divisions in midterm marriages, 60-40, 55-45. I've seen 75-25. I've seen 80-20, which is really rare, those higher end ones, but there can be reasons. I see 57-43. I see all kinds of things. And the reason why is because in a midterm marriage, what you're really trying to do is create more of a rehabilitative situation if one party makes a lot more than the other. Parties should exit the marriage on somewhat equal footing, right? And so a party that makes less or doesn't have an income is automatically not going to recover financially as fast from the divorce as the other party. So they generally might take more. If you were a stay-at-home mom for a number of years, you've been married 18 years, you're probably going to take a good bit more of the community than the other party, right? So that's one issue. And then what is the financial circumstances of the parties at the time you get divorced? How much is everybody making? How many working years do you have left? What's the education? Does somebody need to go back to school to get some training, to get a job? Like what's going on here? Does one party work at Amazon and make 400K a year and the other party teaches for Seattle schools and makes 90K? Like what's the deal, you know? And then we can look at things like what that asset and debt division should be on dividing up that community. It's really important. In a long-term marriage of 25 years or more, all property is before the court in every marriage. So a court can always consider how much separate property. Does somebody have an inheritance? Did somebody get a gift? How much separate property does one party have? Because you're looking at what supposedly is equitable. And when you're doing that, you're looking at the big picture. But in a marriage of 25 years or more, separate property can be divided. So what that means is if you guys have a community that's $5 million and somebody's got $1 million over here of separate property and the other person has none, you're probably dividing $6 million. And that might even look like one person taking more of the community to compensate for it, or it might look at dividing up that separate property. It's hard to say. So there's a lot of different things to know about asset and debt division, but what you need to know is it's going to need to happen. And what is supposedly fair in your situation is probably going to feel different to both of you. And so you're probably going to need some guidance to help figure that out and to know, like, am I getting a good freaking deal? That's the one thing you want to know. Am I getting a deal? This is the rest of my life. Is 50-50 might sound fair. Is it fair? No, sometimes you'll have somebody come to you and I'll be like, that's way less than you would get. Or I have somebody come to me saying, oh, I'm giving them way more than I should be giving them, right? Like you don't know. You need to get a gauge on that, but it's really important. You only get one shot at it. You don't get a do-over. Okay. Next, spousal maintenance. Before I talk about that, do you want me to take a couple questions?
Yes, there's a couple of questions that I think are good and relevant to what you're talking about. So one person saying they understand inheritance is not considered community property. If the inheritance is used to purchase an asset, is that new asset considered community property? And if it's a business asset, does that change it?
Hmm.
It's kind of like starting with inheritance, but now we're spending inheritance money on an
Yeah, you're gonna
asset.
need to talk to somebody, but
Yeah.
let me tell you this. This is that I'm glad you asked the question. It leads to a few things. The character of property. Love to talk about this. All right. Character of property is established when an asset is acquired. Okay, and I'll talk about the inheritance, how that plays in. If you purchase something during, or you take out a debt, because debt, I should put it to you that way too. Debts are also community property. So mortgages, personal loans, credit card debt, unsecured medical bills, anything during the marriage is also presumed community. So if you buy something during a marriage, it doesn't matter. Name on title doesn't control. That's the whole thing with community property. And let me tell you what I mean by that. I go to work at Boeing, let's say. I got a retirement account. I've got a Boeing VIP plan. My name's the only one on them because I'm the employee, right? And my spouse, their name's not on it. But when we get divorced, they still, every dollar that I'm making that's going in there, they have an interest in because it's community. So community means we both have an interest. Community has an interest. It doesn't matter about the name. When you think about real property, same difference. If somebody buys a piece of property during the marriage, during the community, the presumption is that it's community, regardless of name on title. Okay. And the character of that property, meaning if it's separate or community, is established when it's acquired. So if I bought a piece of property 5 years before I ever met my husband and I own it, and then later he comes and lives there and maybe pays money towards the mortgage or whatever, it doesn't change. It's my property. It's a separate property. It does not change. There's a couple ways I could change it, but just by virtue of when it was acquired, it doesn't change. If you purchased a home during your marriage, there is still a presumption that it is community, even if your name is the only one on it. If you used your inheritance as a down payment, you use separate property for the down payment. Did you use it for the whole down payment? Did you use it for part of the down payment? Are both parties' names on title? All of these things matter, right? And so that's why it's going to end. You're going to have the burden of being able to show that you can trace the funds that you put down to separate property. There is a presumption that it's community. If you want to assert that it's separate, you bear the burden of showing through clear tracing that it's separate. So if you, let's say you guys buy a house and you're both on title, but you used $100,000 and the community put in 50. So that's going to potentially have separate property interest in the home, but the home's still community. So there's a lot of different things here. But anyway, character of property is established at the time it's acquired. It can be changed two ways. One, through transmutation, which means an actual writing changing the title of the property. So that house that maybe I bought 5 years before I got married, that house, if I refinanced it and changed the title and put my husband's name on it, that's still not enough. That used to be. But there has to be a writing plus a showing of intent that I intended to make the home community property. I didn't just add them because it was better for financing. So in your inheritance issue, how that inheritance was put into the property, when the property was purchased, how it was titled, whether you can trace it, all those are factors you're going to need to consider. Great question. I'll take one more before I move on.
Okay, if a house was purchased with a parent, but since married, all parties had to sign the title, how would that property be split?
I don't know. How'd you sign the title? How's
Yeah,
the house titled? Did somebody sign a quitclaim deed saying this isn't my property? Did someone sign going on title as husband and wife? Do you own it fractionally with the other people? You got a lot of things you got to look at there. So I don't know.
yeah.
Yeah, I don't know.
Let me ask one more question. How would asset division work with a pension if we're both still in our 30s and we don't anticipate any benefits until retirement? Just
Hmm.
married just over 5 years now, or
Yeah.
young, but yeah.
There'll be a value of your pension. If you have a pension and you're not gonna, and if you're lucky you have a pension, good for you. There's not that many people do anymore. But if you have a pension, however long you're married is going to establish what the community value of the pension is. And this is a good opportunity too. I should talk about mixed character assets. A pension's a good example. So is a 401k. You could use these two interchangeably, let's say. Pension or 401k is going to have a value to it. Okay. Pension's not going to pay out till later. 401k technically isn't either unless you draw on it early or something or take a loan. So let's say, I'll use a Boeing example again. Let's say I work at Boeing for 5 years, then I get married, then I'm married for another 5. My pension has 5 years of separate property character and 5 years of community character. So I'm going to need a valuation done to calculate the gains and losses on those 2 periods and determine how much is community and how much is separate. If you have pensions and you're in your 30s and you're not going to collect on those till a lot later, they're continuing to accrue community value. So your pension, even if you're not drawing on it now, still has a community value. So you'll need to determine what that value is and what that looks like. And the overall asset division, it'll determine how it plays out. But it's still community, even though you're not going to be drawing on it now. So anyway, it's easier usually if one person just is able to keep their own pension and people have equal pensions, but that's not usually the way that it always goes. So I hope that helps. All right, I
Yeah.
want to talk briefly about spousal support. Someone asked about it earlier, and I think it's super important that you understand what it means. Spousal support or spousal maintenance, like I said, is the Washington language for alimony. It's not automatically awarded. It's going to depend on the need and ability to pay as well as other factors. And the other factors that are going to determine spousal maintenance are length of marriage, each spouse's financial resources and earning availability, and the age and health of each spouse. If you're married 25 years or more, you are not working, well, let's say you're no longer of working age, you're going to be looking at equalizing the parties, the two of you into perpetuity. And that could be some spousal maintenance via, um, you know, benefits payments, equalizing if someone's working part-time, any number of things. So that's going to be a little bit different if you are post-retirement, I should say post-working years. If you're in retirement years, it might look different. Let's just say, for the sake of this discussion, that you're both working, you have working years left, and let's say you're in a midterm marriage. I like that example. It's a good one. So every year of marriage, so you take every year of maintenance is what I meant to say, is equal to 3 or 4 years of marriage. There's no statutory formula. There are guidelines and there's case law, but every 3 or 4 years of marriage is basically 1 year of post-divorce maintenance. So I like to say, let's say 16-year marriage, okay? If you're in a 16-year marriage and you're looking at a 3-to-1 ratio, it's about 5 1/3 years of post-divorce maintenance. Or if you are in a 4-to-1 ratio, it's about 4 years. So what's your range of risk on maintenance if you're the breadwinner? Between 4 and almost 5.5 years of maintenance plus temporary maintenance. It's 3 to 4 years of marriage equals 1 year of post-divorce maintenance as a guideline. Are you going to get that in every case? No, there might not be that many working years left, or maybe someone can't afford to pay maintenance, or maybe there's not a need. So there's a lot of different things that come into play, but that's kind of the determination on the ratio of time that you should think about. It's really, really important for you to know that because it's not automatic and it's not a given. However, when you're thinking about maintenance, you really need to think about the length of the marriage as well as the financial circumstances of the parties at the time and the history of the marriage. So, like, let's use this for example. If you are married short term, like if you're married, I mentioned this earlier, like 5, 6 years or less, that's a short term marriage. 5 years technically, but I think 5 or 6 because it's fluid. The principle of short-term marriages, like I said, is to put people back where they started. Nobody's relied on the community long enough to think, I need post-divorce support. However, temporary maintenance can be entered in the beginning of your case and can go on during the pendency of the case, which sometimes could be a year or more, right? 6 months, 9 months. Temporary support and temporary maintenance is a real thing in short-term marriages even, because the parties are just separated. They're trying to establish a new normal. One person isn't working or they aren't making a lot of money. Need to figure out what that looks like, right? And that's a very real thing. Post-divorce in a short-term marriage, you might get a year of maintenance if there's a big difference, or you might not, right? Or you might do a little bit of a disproportionate property division instead of that if someone needs a little extra money. There's a lot of different things you can do. My friend Kim Muska, who's a financial advisor and certified divorce financial analyst, likes to say that Washington is a choose-your-own divorce adventure state, and it's totally true. And what she means by that is you can structure your settlement with spousal support and property division together kind of however you want. Some people will propose a prepayment of maintenance up front at a small discount of 3% or something. And the reason they'll do that is because they'll say there's a time value of money. And if I propose maintenance over 6 years and it's worth $400,000 and I'm going to give it to you out of the property division up front, I'm going to get a little bit of a discount because there's the time value of you being able to get all of that and invest it up front, right? So sometimes people will do that. Sometimes people will say we're going to go no maintenance and just do a different property division. Sometimes people will say there's going to be regular payments every month. Your situation is going to depend on your particulars, but that's a little bit about spousal maintenance. The last thing I will say about it right now is that maintenance payments, this has changed several times over the years, but as of now, maintenance payments from one party to the other. They are not tax deductible to the person paying. They used to be pre-2019. Sometimes it would be advantageous for me to be like, you have to pay maintenance. You might as well pay it's tax deduction to you. And then it's income to the other party, right? Like receiving spousal maintenance was actually taxable income. It no longer is. It's dollar for dollar free money if you're getting it. And there's no benefit to the person paying it. They can't deduct it. So that's very different than it has been at different times. And that might change in the future. I have no idea. But as of now, it hasn't changed. So that's important for you to know. Okay. Any questions that you want me to take, Melissa, on spousal support? I'll take a couple.
Yeah, just a couple. Somebody's asking, there was a question earlier about if somebody had been out of the workforce for a while. Um, what if you have a child with special needs and you're a homeschooling parent? Would you still have to go back to work right away, or is that taken into consideration?
It might be taken into consideration. I'm going to talk about parenting, and we've gone on some of these topics in more detail than usual today. So I'm going to have to talk about parenting quickly. But first of all, if you have historically homeschooled your children and you're going to continue to do so, and there will need to be an agreement of the parties to do so. And that might factor into your situation. But if your position is, I need to stay home to homeschool the kids, the other parties is, well, maybe that's what we did before, but now I don't agree to that. There's a possibility your child will have to go back to school and you'll have to go back to the workforce. So it depends. It really just depends on the circumstances and the decision making in your parenting plan. I'll take one more quick one on maintenance.
Yeah. What about for a long-term marriage, but stay-at-home mom for the entire length of the marriage, but only in the early 50s, but out of workforce for the entire time, health issues, cancer, etc. Any standard maintenance, or is it just so dependent on specifics?
There's no standard maintenance. It's dependent on
Yeah.
specifics. But let's say you were married for 25 years and you're looking at, let's just say, let's say I'm married for 25 years and I'm looking at a 3-year ratio, 3 years to every 1 year. I mean, that's like almost 8.5 years of maintenance. That's probably going to get you to where you need to be. But if you're actually disabled and you're out of the workforce because you're disabled and you can show disability, you might even be able to get more. It really just depends. And it depends on the income of the other party and like what the financial resources are. Or it depends on if there's so much community that you don't really need it because you can live off of the community and whatever you're going to get. So it depends. But most of the time in a 25-year marriage or more, you're going to be looking at significant maintenance. If you're not working, you've been out of the workforce to stay home the whole time, that's a maintenance case, is what we would say. That's what we would say. So I want to talk about parenting, and usually we'll do a whole webinar on parenting. There's been several of those over the last couple of years. So tune in next time or find one on our YouTube channel. But anyway, parenting plans. A parenting plan is basically what some states call a custody order. We don't really use the term custody that often in Washington. We use friendlier terms like parenting plan. We don't say custody schedule, we say residential schedule. So what's in a parenting plan? Everybody has to have one if they have kids and they're getting divorced. Residential schedule, where the kids live when. That's one basic. Holiday schedule, where the kids spend holidays. Summer schedule, is your summer schedule going to be the same when kids are in school as when they're out of school? Vacation, are the kids going to have additional time during the summer for vacation with the parents? So those things are decided. Decision making. Somebody asked about homeschooling. This is a big one. Decision making is huge. Parties are going to usually have joint decisions, which means they'll have to make decisions together unless there's a basis for limiting factors. And I'll talk about that in a minute. But the major decisions that go in a parenting plan that people have to decide about are education, what school, homeschool, not homeschool, those kinds of things, non-emergency medical, things like orthodontia. Do you need orthodontia? Do you need braces? Does a kid want to go to therapy? Non-emergency medical. Emergency medical is in the purview of the parent who has the kids at the time. Like if my kid falls and breaks his leg, I don't have to go and find my former spouse and be like, can I take him to the ER? No, you take him to the ER, right? And then you notify them as soon as possible. So non-emergency medical, extracurricular activities is a joint decision making if it crosses residential time and both parties have to pay for it. So that's another thing. Extracurriculars, non-emergency medical, education, those are kind of the big ones. You can put other ones in there as well if you want to. Some people will go as micro as to say cell phone usage or social media usage by a child, but you don't have to have that in there. So it's really the big three, though. It is education, education, extracurriculars, and non-emergency medical. Those are the main things. So anyway, those will need to be joint decisions. A good parenting plan will have a protocol for how to make those decisions together. And then every parenting plan will also have a dispute resolution provision. So how the parties are going to settle disputes about decision making, or if there is a disagreement about a decision in the parenting plan. So those things are all super important. Restrictions, oh, transportation also goes too. Where are the kids going to be dropped off and by whom? Is it going to be exchanges at school? What about when school's not in session? Who's going to do what when? All that stuff goes in the parenting plan. The restrictions section, in the beginning of a parenting plan, there's a section called Section 3. Section 3 will have 3A and 3B restrictions. 3A restrictions are typically domestic violence most of the time. If there is a protection order in place, if there is a history of domestic violence, if there is anything like that. 3B restrictions, there's other kinds of restrictions as well. Substance abuse, mental health restrictions, neglect, abandonment. Now, there needs to be a nexus between those kinds of behaviors and the actual parenting. Someone can have a drinking problem and have gone into recovery, and it doesn't affect their parenting, and there's no issue, there's no restriction there. Or someone can have had mental health issues, but if there's no issue with parenting, then it's not a restriction. So if there is a restriction, it can be a basis for reducing time with the child, and it can be a basis for sole decision making in certain areas or all. So those are all really important things. A lot of people want to know, is Washington always a 50-50 custody state? No. Washington's standard for evaluating what goes in a parenting plan is what is in the best interest of the child. And that means the child, not you. So a parent can't say, oh, it's in my best interest because of my work schedule. Well, no, what's in the best interest of the child? Like what's best for them, right? So the parenting plan also will include, I should note, the relocation statute. If a parent that has more than 45% of time wants to relocate out of a school district, then they have to give notice to the other parent, and that protocol is in there. So you can't even just move from like Seattle district to Bellevue district later if you're the primary parent without giving notice, and then the other party has an opportunity to object. Or you can't move like from Seattle to Boston or whatever. So anyway, parenting plans include a lot of really important decisions, and they are fundamentally one of the most important parts of divorce. I am going to touch on child support, and then I'll go a few minutes over, just take a few more questions. Child support, this is where there actually are standards. Washington uses a standard child support formula, not like maintenance, where it's very discretionary and kind of, it depends on the facts. So the formula looks at each parent's income, the number of children, and who has more nights. So child support continues until a party turns 18, a child turns 18 or graduates from high school, whichever is later. So two components of child support. One, the transfer payment that's based on the formula. So let's say you've got a couple of kids, you have a formula for how much the child support is for each, and then the parent, and then it's split basically proportionally based on how much the parents make. Maybe one parent makes 70%, one parent makes 30%, okay? So it's a 70-30 split of that child support number. The party that makes more, the party that has the majority of the residential time, they get the portion from the other party. It's pretty simple. And there can be reasons to deviate from that. Like if somebody has a 50-50 schedule, the deviation might be different because the party paying has more time with the kids. There can be any number of other reasons, but deviations are not automatic or guaranteed. You usually just count on what's on the child support worksheets. You have to have worksheets that give you the numbers, okay? And there are things in the child support order like who's going to cover the child? Is the portion of the premium going to be included in the calculation or handled outside of it? There's also going to be that proportional share that covers things not covered by the child support transfer payment. So child support transfer payment is basically meant to be food, clothing, shelter, basic life necessities. Okay. Things that are not covered are extracurricular activities, education, things like that. Those are anything that is not a basic life necessity. And that's split along, like, for example, I was talking about that 70-30 line. There'll be a pro rata share for out-of-pocket expenses, non-emergency medical copays, things like that. Soccer for the kids, things like that. So there's a whole lot to know about child support. But the best thing is usually figured out last, because you have to know if one party's paying maintenance to the other, because maintenance is factored into as far as figuring out child support. The person paying it, obviously that's coming out of their income before a net income calculation. The person receiving it, that's obviously going on their side of the worksheets. So all of those things matter, and child support is usually the last thing we do because it's kind of the easiest. So that might not be what you expected to hear. We only have a couple more minutes, but I'm willing to take a few minutes over and answer a couple of questions, Melissa.
Yeah, thanks. There's been so many good questions today.
Yeah.
I just put our contact slide up here so that you have this information. So I'll leave it up here for the duration, but just wanted to put your eyes to that. Couple more questions. Somebody's asking, this is kind of going back to community property stuff. If a business is created with only the husband's name during the marriage, is that considered community property? But if it was created during the marriage?
Yeah, name on title doesn't matter. Good.
Okay. And then, yeah, that's a good one. And then back to kind of parenting plans. How much say would a 16-year-old have in a parenting time split?
None. When do kids get to decide where they live in Washington? How about never? Some states will be like, oh, when the kid's above 13, they get a say. That being said, I'll give you my spiel on this. It's really difficult to control teenagers. A lot of time they're going to do what they're going to do. If there's a real concern in your case and a real hard time figuring out what should happen for residential time, you might have a guardian ad litem or a parenting evaluator. And a guardian ad litem or parenting evaluator will talk to your children and they will talk with them. And they're probably going to, if your child is 16 and they're able to more articulate where they want to live, sure, but they're going to look more at like, why are they saying that? Are they saying that because at one parent's house they can play video games and there's no bedtime and no one makes them do homework? Or are they saying that because they can really articulate, I feel safer here and this is why? So they don't get to make the decision, but what they say might have more, it's more valuable input than what a 2-year-old or a 3-year-old is going to say when you just kind of don't know. So, but no, they never get to make a decision. Children are never given a choice.
Thanks so much. I think we cleared all our questions, which is
Perfect.
awesome. And we just
Good.
kind of just right on time. So thanks so much, everybody, for attending today.
Yeah, thanks for coming. You guys had a lot of great questions. I hope this was helpful to you. We do a foundation series once a month. We also do a special topic series. So we do 2 of these a month. So that's good and important for you to know. The other thing that we do every month that may actually be something that you're interested in or that's helpful to you is the last Wednesday of every month, we do a meetup group. And really what it is online, we used to only do them in person, and then COVID happened. And then I realized, oh, it's better to do them online because a lot more people can come. So we do them online, except for once a quarter, we're in person. So the next one there, I believe is, I think August 27th, and that's online from 5:30 to 6:30 p.m. You can sign up on meetup.com and you can link to that from our website if you're interested. You can come, ask questions, hear other people's questions. It's more of like an open dialogue type situation. We are doing an in-person one at Cascadia Pizza in Bellevue, which is where we usually meet, and that's in September. That's a more limited audience, basically, because the room only holds so many people. You can come, I don't know if it's limited to maybe 15, I don't know, something like that. But you can come and talk with other people if you want, or just come and hang out and listen. We'll answer your questions in person, get to meet you. If you'd like to chat, you can. We'll have food and drinks and it's totally free. So in person if you want, online if you want. Otherwise, you can check out our webinar programming and so on and so forth. So I hope this was helpful. I hope you have a nice day and enjoy the rest of your Seattle summer. Take care.
Thanks again, everyone. Once again, those dates Michelle mentioned, the 27th is the online meetup group. And then the in-person meetup that she was talking about was on September 17th. So yes, please reach out to the firm if you're interested in scheduling a consultation and getting more detailed information. Feel free to reach out to me if you're interested in discussing counseling services. And thanks for attending. We'll see you next time.